It's Nolan.
Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Hold up now. Far from a talent, I was brought up on the Bible. Mama gave me brandis on the side like a rifle. Float through the water, need a royalty for title. Wrestle with the hater, lemonade, roddy pipe. Wait, I was in the studio pulling all night. You was at the block party dancing like Mike. I was on the go for the green light, taking down mics and I'm a wrist. I ain't talking all right like whoa. Monopoly money cover the drawer. Running up the score, putting numbers on the board. Never let a dollar go, I've been on the horde. Banging on the boat, finna send it all short. Yeah, why you count mine? I ain't eating off yours. Put it in the ceiling of the walls of the floor. Well, they ain't half of my name on scores. I ain't gotta chase fame, get the cash straight for it, no count. Only can focus on C-notes, thought like I'm Vito. Pour up the vino, roll out the carpet, get more like casino. Tell me the price, I say no necesito. Got it on tape, posted up like it's Vivo. Trap out my house with my pen, but it's legal. I sweep my girl off her feet like torpedo. She order mojitos, you boy super keto. On the grind since ninth grade, been on the grind since MySpace. Putting on my time in the right way. Money coming back when you fly straight. Niggas don't know what my life take. Smiling and every on sideways. Bringing in cash, these fight rates. Living like that, it's Friday.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there on this Friday evening. In this video, we're going to be getting into Tory Lanez. He has come back out once more. Last time we talked about Tory Lanez, his appeal was denied. He's currently serving time out in California for the shooting of Megan Thee Stallion. And now he's coming out saying that he has new evidence, right? And that they're going to try to appeal once more with, I believe, the, Supreme Court? Yes, he is planning to file his appeal to the Supreme Court, okay? So his prior appeal was sent to California's 2nd District Court of Appeal. Once again, they denied it last month after they found no ineffective assistance of counsel or prejudicial trial court error in his appeal. However, again, he's claiming that they have new evidence, all right? So they're going to be filing under the Brady Rule. And I'm reading here, the Brady Rule was established in 1963, which requires prosecutors to turn over materials or potentially favorable information to the defense. Okay? Now, in addition to him trying to file this appeal, which we don't know if that's going to go right or left for him, it looks like he's trying to get a contingency plan for that by trying to request a pardon or some form of clemency from California Governor Gavin Newsom. Now, what I find to be very interesting about this Gavin Newsom situation is this is the same man that's out here playing Megan Thee Stallion music. Not to say that he would be favorable to Megan because of that, but damn. All right? So it's a lot of different things at play here, but we don't know anything at this current point of what he claims to have. This isn't the first time that him and his legal team have come out and said that they have new evidence or things that were unseen at trial. They came out with a whole PowerPoint presentation earlier this year. It wasn't all that compelling, but he does have some MAGA people behind him that are pushing. He has the people like Diana London, Rep. Paulina Luna that have rallied behind him. They haven't been too much of a help up to this point, but that's the strategy. I saw some folks in the chat yesterday when I was talking about Megan filing that injunction on Milagro that was saying that he was going to appeal. At the time, I didn't know anything about it. All I had known was that his previous appeal was denied. But again, we'll just have to see where things go from here. I don't know what type of information he believes that he's going to put on the table that's just going to exonerate him of everything he feels he was wrongfully convicted. But nonetheless, let's go through this this interview that he did with NBC. For some reason, they gave him a platform to talk about it.
Tonight, rapper Tory Lanez breaking his silence in his first ever broadcast interview from behind bars since being found guilty of shooting Grammy winner Megan Thee Stallion in the foot outside a party in 2020.
I've never been violent towards a woman. I would never hit a woman, let alone shoot a woman.
Lanez, whose real name is Daystar Peterson, spoke to NBC News from California Men's Colony, a prison where he's 3 years into a 10-year sentence after being found guilty on 3 felony counts, including assault with a semi-automatic firearm.
There is definitely a very big misconception about me that seems to the public as I'm this monster. And I feel like I was catapulted into this poster child for the unprotection of Black women. And it's just so unlike me. And I've never really had a chance to express that. But you can look at my criminal record. I don't have one. I never had one. And I feel like, that connotation that I would do anything of this monstrous proportion is completely incorrect and it's wrong.
Lanez declined to testify during his 2022 trial.
Do you regret not taking the stand?
I think if I would have taken the stand, the verdict would have definitely been very different.
The rapper's legal team filed an appeal, which was denied in November. But his team is continuing to fight, with plans to file multiple appeals next week, this time with the California Supreme Court, in one claiming newly discovered evidence that they weren't provided during Lanez's 2022 trial, including hundreds of pages of medical records for Megan Thee Stallion, whose real name is Megan Pete, which they allege raise questions about the fragments removed from her foot after surgery. His team argues that the fragments were not provided ahead of trial and that this was a violation of due process.
And we didn't have that chance. Or perhaps we could have questioned the doctors differently when they were on stand to impeach them, because it does look suspicious.
But in the appeal denied in November, the court did address the fragments, ruling that the surgeon's testimony was, quote, more than sufficient to prove great bodily injury on Pete. Proving something like this on appeal is tough.
This is a really, really difficult appellate argument for defendants to prove, because they have to show if the evidence actually came into court, the jury would have found differently. It's an uphill battle, and it's something that often torpedoes any defense appellate argument.
The Los Angeles District Attorney's Office and representatives for Megan Thee Stallion have not responded to NBC News' request for comment.
I believe not only that I was wrongfully convicted, but the amount of new evidence that has emerged since that trial, I think, has been overwhelming.
What has life been like in prison for the last couple of years?
Truthfully, I've done my best to keep my head above water, but mentally, I've gone through trauma that I sometimes even struggle with, because I never imagined myself dealing with things that I would have to deal with. I've been stabbed 17 times. I almost lost my life.
If you could say something to Megan Thee Stallion today, what would it be?
I think that I wouldn't say something directly to her. I'd like that moment to happen in person. We've both gone through a lot.
What?
There's this connotation that, like, I share this hatred for her, but I don't. I genuinely passed that. I'm at a place of healing in my life. I'm at a place of taking accountability for the things that I did wrong. And when I talk about my case, I don't want it to be taken as me coming at her, because it's not that. I'm just asking for somebody in the system to look at my case and look at the evidence and ask if this was fair.
And with that, Chloe Malas joins us now on set. So, Chloe, Tory Lanez is also seeking a pardon from Governor Gavin Newsom?
That's right. His legal team has filed the necessary paperwork, and it is before the governor now. So they're seeking either a pardon where his criminal record will be wiped clean, he would be released from prison, or to have his sentence commuted, meaning that the time he has served is sufficient, and release him, but that doesn't change his criminal record. As for when this could happen, the governor typically does these twice a year, so this could happen before the new year.
All right. Chloe Malas for us. Chloe, thank you. We thank you for watching. And remember, stay updated on breaking news and top.
All right, folks. So that is Tory Lanez's interview with NBC Nightly News. where he, I guess, tried to plead his case. He claims that he was wrongfully convicted. He said things would have gone differently had he taken the stand. But even in the denial from the judge in his previous appeal, they showed how many times the judge during that trial offered him to take the stand, right? And he consistently denied. So I find that to be very interesting. Him saying I don't want to send a message to her. I would rather that be in person. Sir, do you think you will ever in your life have the opportunity to be around Megan Thee Stallion again? What you mean you rather say it in person? Are you crazy? Oh, I don't have nothing negative to say about her. I'm in a place of healing. Sir, did you listen to the last album that you put out that you recorded from behind bars? Didn't you have about 2, 3, 4 songs on the album where you was dissing her? And shouting out Milagro? What the fuck type of warped reality are we listening to and living in here where you think you could go talk to some white folks at the news and everything else just suddenly disappears like it never happened? Now, I'm not going to lie. I've done this once before. I've read the denial of his previous appeal, okay? I've read it on this channel, but I do want to pull up some of it and reread it for the people because now he's filing another one and he's saying that he was wrongfully convicted. He says that he had no criminal record. So I just want to read through some of the things that this second district appellate judge had to answer to in his previous appeal, just so y'all can see what's going on here. I'm not going to read the entire response, but I do want to go through this because it's easy to forget. This stuff passes by. News cycle goes quickly. But let's just go here. So right here up top, it says Peterson also asserts this testimony was irrelevant and prejudicial because it elicited sympathy for the victim. That's in reference to Megan Thee Stallion taking the stand in his trial, right? The one that he was convicted in. So the judge says, however, at the outset of the trial, the court instructed the jury, your verdict must be based only on the evidence presented during trial in the court and the law as I provided to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume that the jury understood and followed the court's instructions in reaching its verdict. Here they say evidence code section 352.2 does not apply retroactively, and the trial court did not abuse its discretion in admitting a photograph of Peterson's torso and arms. Peterson contends the trial court reversibly erred in admitting evidence of Peterson's creative expression. This is about his tattoos. Okay? Specifically, a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and her partner stopped a vehicle that matched the description of a vehicle in a radio call they'd received. So he believes that his photos being used in court showing his tattoos was some sort of prejudicial decision, that he was convicted partially because of the tattoos on his body, like he was a thug. Okay? 4 people, later identified as Peterson, Pete, Harris, and Smith, were in the vehicle. An ambulance took Pete away, and Cabral and her partner arrested the other 3 and took them to Hollywood Station for further questioning. As the officers had found in the vehicle a handgun that was warm to the touch and in the slide lock position, when they got to the station, they tested Peterson, Harris, and Smith for gunshot residue. Okay? Peterson as in Tory, Harris as in Kelsey, and Smith as for, Jaquan, the security guard, all were tested. The prosecutor marked as exhibits 3 photographs taken at the station that depicted Peterson, Harris, and Smith respectively. In a photo marked as Exhibit 18, Peterson appears to be wearing black shorts or swim trunks. He is shirtless, and tattoos on his chest and arms are visible. He was naked when the photos was taken, or at least naked up top. In a photo marked as Exhibit 19, Harris appears to be wearing a black two-piece swimsuit. Tattoos are visible on her arms and left thigh. In a photo marked as Exhibit 20, Smith appears to be wearing black pants and a long-sleeve black top. At sidebar, Peterson's counsel objected to the photograph, arguing it was irrelevant and would only sway the jury because it looks like he's got tattoos. The court replied the photos were to show who the people were that she, the officer, took the swabs from. So the photos indicating his tattoos was not to show the tattoos, but just to show who had been taken in for questioning and for evidence, for testing. He just happened to not have a shirt on at the time. The court continued, I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court asked defense counsel if he had any objection to the admission into evidence of exhibits 18, 19, or 20, he replied, no. Okay? So at the conclusion of the evidence, the judge asked once more, Tory's lawyer, do you have an issue with these exhibits, these photos, including the one of him with his tattoos? At that point, his lawyer said, no. Then you want to try to bring it up in your appeal. In support of his claim of reversible error, Peterson cites Evidence Code Section 352.2 Assembly Bill, which took effect on January 1st, 2023. The statute requires trial courts to consider certain factors when a party seeks to admit as evidence a form of creative expression in any criminal proceeding. The statute defines creative expression as the expression or application of creativity or imagination in the production or arrangement of forms, sounds, words, movements, or symbols, including but not limited to music, dance, performance art, visual art, poetry, literature, film, and other subjects, such objects or media. Peterson cites People v. Venable. In Venable or Venable, the Court of Appeal held Evidence Code Section 352.2 applies retroactively to cases that are not yet final. In his opening brief, Peterson failed to note that our Supreme Court had granted review in Venable some 9 months earlier. Peterson also failed to cite either of those two cases that reached the opposite conclusion. In his reply brief, Peterson acknowledged the grant of review and mentioned Slayton. Peterson stated he relied on his previous argument pending a final outcome in the High Court. On August 28, 2025, our Supreme Court held in Aguirre that Evidence Code Section 352.2 does not apply retroactively. Aguirre involved handwritten rap lyrics and instant messages attributed to the defendant. Chief Justice Guerrero explained that the High Court, having examined the language of Evidence Code Section 352.2 and its uncodified legislative findings, saw nothing that clearly and unavoidably reveals an intent to depart from the general rule of prospective-only application. Accordingly, Evidence Code Section 352.2 does not assist Peterson. So in his own appeal, he incorrectly cited case law, which did not work to his favor regarding his tattoos. In any event, the record does not support Peterson's contention that Exhibit 18 injected racial bias into the proceedings. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang allegation in this case, and no one ever suggested that Peterson had any gang ties. So typically, if a tattoo is referred to in court in a way that would incriminate somebody, would typically be for some sort of gang affiliation, which there was no such allegation in the case. Again, incorrectly citing case law. The prosecution offered Exhibit 18, 19, and 20, and the court admitted them into evidence solely to show the identity of the individuals officers swabbed for gunshot residue at the police station, and unfortunately, he was unclothed on his chest and arms when he was in the police station. That's the photo he took there. It's not like they went on the internet and found a picture of him with no shirt on. The record does not reflect whether Peterson was wearing a shirt when police stopped his vehicle. Pete testified they just emerged from the swimming pool. She was wearing a bikini, and Harris was in a swimsuit too. Pete's stylist, Eric Culberson, called by the defense, also testified both Pete and Harris were wearing swimsuits when they got into the SUV. Culberson also testified Peterson was wearing drawers when they left Jenner's house. In his closing argument, Peterson's counsel referred to what Peterson was wearing as his trunks. There was no testimony at trial that Peterson had been wearing a shirt, and the officers asked him to remove it in order to swab his hands for gunshot residue or to take his photograph. So they really don't know if he ever had a shirt on. But no one ever asked him to remove it. Okay? I'm pulling this up because this is the judge's response to his appeal of what he said was prejudicial. People always try to say, oh, this channel is so biased. How can I be biased when I'm going by the paperwork? You just don't like that I'm asserting the paperwork rather than your emotions or how you feel or what you want to be the truth. I'm tired of this fucking case. I would rather not talk about it at all. Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. Defense witness Culberson testified he was Pete's stylist and friend. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Culberson to ask him if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Culberson if he'd ever seen Tory with a gun. Culberson replied, no. Counsel asked if Peterson ran around with guns. Culberson answered, no. Okay? So he improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. The defense witness testified he was Pete, as in Megan's stylist and friend. He was sometimes Megan's driver as well. It appears the defense Culberson asked him if Pete or Harris had a gun. Okay? They also asked if he'd ever seen Tory with a gun. He said no to both. So where's the racial bias? On cross-examination, the prosecutor asked Culberson a series of questions about whether he'd ever seen Harris with a gun and whether he'd seen Pete with a gun at any time that day or night. He did not ask Culberson if he had ever seen Peterson with a gun. On redirect, defense counsel then asked Culberson if he'd ever seen Peterson with a gun, if he'd ever seen Peterson have a bag that had some weapons with him, and whether he'd ever seen Peterson discuss anything about firearms. Culberson said no to those questions. So it was Tory Lanez's own attorney who even introduced the object of Peterson, as in Tory, having a gun on him. It wasn't even the prosecutor. So where's the prejudice of race? On recross examination, the prosecutor and Culberson had the following exchange. Now, counsel asked if you've ever seen Tory talk about guns or if you've ever seen him with guns. Do you recall that? He says yes. Do you see the big gun that Tory has tattooed on the center of his chest? No, I haven't seen Tory's body. Defense counsel did not object to that question. So when the question was asked about the gun on his chest, there was no objection to it. In short, the record does not support Peterson's contention that prosecutors utilized Peterson's tattoo, which is intertwined with his rapper persona, to lead jurors to conclude he is a violent criminal with a disposition, to commit crimes. It was defense counsel who asked both on direct and on redirect, and defense counsel was Tory's attorneys, if Culberson had ever seen Peterson with a gun. Neither of the prosecutors even mentioned Peterson's tattoos, much less the tattoo of a firearm, in their closing argument. So it had nothing to do with the decision making. Peterson also complains that Pete, as in Megan, her testimony about a music video Peterson had released poisoned the proceedings by directing the jury to infer that if Peterson was chopping up horse legs in a music video, he was violent enough to shoot her. Peterson seems to be referring to Pete's answer to the prosecutor's question about whether she regretted having come forward. This is a quote from Megan. If I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I would have known, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I gotta watch Tory drop music videos chopping up horse legs and people laughing at it like that's okay. Defense counsel did not move to strike Pete's reference to the music video. So at no point did Tory's attorneys object to that testimony. No such music video was offered into evidence or shown to the jury, so they never even seen the video. They only heard about it through Megan. In any event, Pete's brief reference to the video, which she took as directed at her or even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Pete's attitude about the case or about testifying. The trial court did not impermissibly chill Peterson's right to testify, and as Peterson did not testify, he cannot raise this issue on appeal. So this is where the previous judge that denied his appeal gets into his decision to not take the stand. The very decision he's now regretful about. Peterson asserts the jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Peterson mischaracterizes the record. Midway through the defense case, the prosecutor told the court he was asking to inquire about prior acts of violence. If Peterson testified, to rebut the character evidence put on by the defense. The court replied, well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say, but at this point, I will exclude that. The prosecutor listed a number of items with which he proposed to impeach Peterson, including social media posts, rap lyrics, Instagram posts, a 2019 Miami incident, a 2022 incident with August Alsina, an incident with Love and Hip Hop star Prince at a Florida nightclub, and more. He would have to answer to those. The court stated some of this would be admissible, those portions that pertain to this case. Some wouldn't. The court continued. The best I can tell you at this point is if your client testifies, I'll have to take it on a case-by-case basis, but essentially, anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't. It depends. After the defense had called 7 witnesses, the following exchange took place. The court. So, Mr. McDesian, you've advised me that your client has elected not to testify. That's correct, Your Honor. The court. So, Mr. Peterson, you know you have the absolute right to testify if you choose. You have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I told you so far? Peterson, that's Tory. He says, yes, Your Honor. The court. Have you had a chance to discuss that decision with your attorney? Tory says, yes, I have, Your Honor. The court. And based on your discussion, is it your choice at this point not to testify? Peterson, Tory, I will not testify, Sam I am. Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution. In Luce v. United States, the Supreme Court considered a case like this one in which a defendant did not testify and then argued on appeal. The court had abused its discretion in denying his motion in limine to preclude the prosecution from asking about a prior conviction. The court stated, a reviewing court is handicapped in any effort to determine if a trial court performed the necessary balancing because, to conduct that review, the court must know the precise nature of the defendant's testimony, which is unknowable when, as here, the defendant does not testify. So how are you being prejudiced by certain questions when you refuse all questions because you don't want to answer to nothing? Of course they're going to ask you questions that could possibly incriminate you. You're on a criminal trial, nigga. That he would testify if his request to exclude possible impeachment were granted, nor did he make a proffer to the court as to what his testimony would be. Moreover, a reviewing court cannot assume that the adverse ruling motivated a defendant's decision not to testify. Even if these difficulties could be surmounted, the reviewing court would still face the question of harmless error. The Supreme Court concluded the careful weighing of probative value and prejudicial effect required of a trial court can only be evaluated adequately on appeal in the specific factual context of a trial as it has unfolded, not conjecture, not projection of what you think would have happened, only as it unfolded. It is well established that the denial of a motion to exclude impeachment evidence is not reviewable on appeal if the defendant subsequently declines to testify. The Luce's court reasoning is directly on point here. Peterson argues Luce does not apply because that case involved possible impeachment with a prior criminal conviction. And 2, the evidence code section 352.2 would have required the court to exclude all of the possible impeachment evidence. Could have swore they already told you 352.2 don't really apply to you. We are not persuaded. Nothing in Luce suggests its holding is limited to impeachment with a prior conviction as opposed to other types of conduct or acts. And as we have said, evidence section code 352.2 does not guide us in this appeal. Okay, I thought so. The mention of Peterson's criminal case in Florida was not prejudicial. Okay, so this is where they get into gun charges he previously had in Florida. Peterson asserts inculpatory statements which were inculpatory. Remember, he said in an interview he doesn't have a criminal record or had no criminal record. Clean as a whistle. Inculpatory statements which were inculpatory as to the shooter's identity were improperly introduced in spite of their factual falsity. Peterson apparently is referring to Pete's testimony that shortly after the shooting, when she and the others heard police sirens and Peterson offered her and Harris $1 million. Peterson offered her and Harris $1 million. Peterson said, "I can't go to jail. I already got caught with a gun before. Don't tell on me." A few questions later, the prosecutor asked Pete, "What's he saying exactly?" Pete replied, "I'll give y'all $1 million if you don't say anything. I can't go to jail no more. I'm already on probation." That is what Megan Thee Stallion says Tory Lanez said to her and Kelsey. In the defense case, Peterson's counsel recalled the lead detective, Ryan Stogner. Counsel questioned Stogner about his interview of Pete after the shooting. Counsel asked if Pete had told him that Peterson stated, "Please don't say anything because I'm on probation." Stogner began to answer. It was something to that. When the prosecutor objected, the court overruled the objection. The exchange followed. "Sir, did you do any investigation afterwards to find if my client was on probation at the time this case was happening in July of 2020? Yes. Was my client on probation, sir? No, not to my best recollection." Right? So here they say, well, all right, if Megan says that Tory told them he was on probation, they went and looked it up and they say, well, he's not on probation. So why did he tell them that? After defense counsel asked Stogner about probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. So here they get into the technical aspect of what was going on because they try to make it seem like his record is squeaky clean. But here is the detail, the context. She added that even if that were not the case, defense counsel was accusing the victim of lying about what Peterson had said. Defense counsel stated Peterson got arrested in the Miami case but was never charged. Outside the juror's presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion for a gun possession in 2017. Not sure how many of y'all have ever had to deal with such diversions, but typically they do diversions for people who get caught in some shit, but then they offer you an opportunity to sweep it under the rug. He released an Instagram live video where he talks about going to his probation officer. After more discussion, the court stated, "I will allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what the arrest was for, and we'll leave it at that." Later, defense counsel and the prosecutor stipulated to advise the jury that Peterson was ordered a grant of diversion for a criminal case in 2017, and that diversion was terminated in April of 2017. The court told the jury the stipulation meant that is a fact that it's not in dispute in this case, and they were to accept that as conclusively proven. So they had to move forward with no, they could not use probation or previous gun charges in their decision making, right? Because they showed them the diversion, right? And they said, don't even worry about what the arrest was for. So those were the jury instructions. Tory was the one who introduced this situation to Megan and Kelsey as the police were approaching. Had he not mentioned probation, I'm quite sure she wouldn't have mentioned probation. Both counsel also agreed to a special jury instruction about diversion. Now, he could have been lying or he could have been misunderstanding the situation. However, those were his words. And when I say lying, he could have been saying, hey, I'm on probation, as his way of saying I can't get in trouble no more, knowing that he already had completed his diversion program. He just didn't want nobody to speak to the law. Both counsel also agreed to a special jury instruction about diversion. In accordance with that agreement, the court instructed the jury about the nature of diversion. The instruction stated, diversion and probation are not the same. You are not to speculate about the circumstances of Mr. Peterson's grant of diversion in 2017. It was terminated in 2017. Once again, these are jury instructions for them to not worry about it. And you are not to conclude from this evidence that Mr. Peterson has a bad character or that he's disposed to commit crime. So how was their decision-making prejudicial when they were instructed not to use it against him? Thus, after the prosecution asked Pete about Peterson's statements, defense counsel raised the issue of probation with the detective in an effort to show Pete lied to the police. So now they try to put it on her that she lied. Pete's testimony that Peterson said he'd been caught with a gun before was not false. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error on this point. Okay? So there's that. I'm not finna reread this whole thing. I just wanted to point out some of the main points that he talked about in his interview. The rest he can address in his appeal whenever it's filed. We'll have to read through that again. Don't want to, but if it's publicly available, I'll get to it. Now, there's some people online that are circulating allegations of possible domestic violence from Tory Lanez. Personally, I don't know anything about that. They're showing a shade room story of, I guess, an ex-girlfriend of his that claimed that he was abusive. Again, I don't know about that. I don't believe he was ever charged or convicted on those allegations. So I can't really weigh too heavily on that. But if that were proven true, that would also show that he was not being forthcoming or forthright or truthful in his NBC interview. Again, I cannot verify that. I will not put that as a stain on him because I do not know the extent of that situation. But I'm just saying there are people that are spreading that around to counter his statements. All right. In all of this, I implore y'all, all right? So I want to go ahead and put this statement out there for everybody, no matter what side you fall on. Read the information for yourself. Don't take the information from me. Don't take the information from your friend. Don't take the information from a stand page that you follow who feeds you what they want you to know. If you have the ability to go find this information for yourself, read it for yourself, especially if you're passionate about this. If you feel truly in your heart that Megan Thee Stallion is a liar, go find this information the same way that I did. If you feel in your heart that Tory Lanez is a fuck up and you really want to drive that point home, go find the information yourself, read it for yourself, take some time, dedicate an hour. We all went to school to learn how to read. I know everybody's not good at it. Comprehension is a whole nother bag. But if you feel passionate about any of this, either way, and you don't already have firm facts, they are available on paper. That's all we can really go off of. Everything else is opinion, emotions, and feelings. I'm going to catch y'all on the next one. Y'all be good out there. Much love and respect. Let me know what y'all think down below in the comments. I'll see y'all a little bit later. More content on the way. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy cause consulting for the stacks I built.